Welcome to this class on equality and non-discrimination. Just allow me to introduce myself. I am Judith Schönsteiner, Director of the Human Rights Center at the Diego Portales University in Chile. I hope you find this introductory class useful. At the end of the class, you will solve a case and apply what you are learning. So, let's get started. Equality and non-discrimination are two sides of the same coin. This means that depending on which concept of equality we choose to adopt, our conception of discrimination might also change. For example, if our concept of equality only encompasses equal treatment, we would think that while we treat everybody exactly the same, no discrimination takes place. To the contrary, if we think that equality comprises elements of equal outcomes for persons, despite their differences, we would want to make sure that the person with special needs receives the means to reach that outcome, even if that involves spending more resources than for another person. Special needs education is a good example for this kind of non-discrimination, usually called equality of opportunities. This class will make you familiar with the most important concepts of non-discrimination, as they are enshrined in international human rights law. We will close by briefly reflecting on public policies to eradicate structural or socially embedded discrimination. All major international and regional human rights treaties contain a clause that prohibits discrimination. All read similar to Article 2.2 from the International Covenant on Economic, Social and Cultural Rights. The states parties to the present covenant undertake to guarantee that the rights enunciated in the present covenant will be exercised without discrimination of any kind as to race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Discrimination in that sense is defined as an arbitrary distinction between two persons belonging to two different groups of persons. Other treaties, like the American Convention on Human Rights in its Article 24, additionally contain a general right to equality, which also operates in relation to rights or situations that are not enshrined in the treaty. This means that states have the obligation to implement non-discrimination policies with regard to all situations, even if no international human right is at stake. Doctrine and case law call the list of prohibited distinctions prohibited grounds of discrimination, included, for example, in Article 2.2 of the International Covenant on Economic, Social and Cultural Rights just quoted. Traditionally, these grounds have been race, religion, and sex or gender. Human rights treaties usually contain open lists of these grounds by including a final category that comprises other status or any other social condition. This open-ended wording, which states have given to the prohibition, has allowed tribunals and committees to apply an evolutive reading to these categories, including over time new grounds of discrimination that societies had not been aware of earlier. Thus, disability, sexual orientation and gender identity as prohibited grounds were, for example, introduced through interpretation. You can learn more about the specific kinds of discrimination in the upcoming classes of this course on gender, sexual minorities, indigenous peoples, and migrants. These prohibited grounds operate as a reason to invert the burden of proof in cases in which the law, state organs, public officials, or private actors make a distinction between a person who displays any of these characteristics and another one who does not. After making a prima facie case that such a distinction took place, for example, between two workers of different skin color, the burden of proof turns to the state or the private actor to show that the distinction was legitimate, necessary, and proportionate. If it was not, the distinction is arbitrary and constitutes discrimination. The necessity test looks somewhat different in the different human rights systems. However, a common feature is to allow certain restrictions to the right to equality, but only if the interference is necessary and proportionate, in case public health, national security, or the rights of others are at stake. Nevertheless, it is not allowed to restrict the right more than absolutely necessary. Thus, if there is a solution that is less invasive to individual rights, that one is to be preferred. There are different types of discrimination to be distinguished. According to the jurisprudence of international human rights tribunals and the UN Human Rights Committees, all of these come under the scope and meaning of the prohibition of discrimination in international law. General Comment Number 20, issued by the Committee on Economic, Social and Cultural Rights in 2009, gives a useful oversight. All of them have in common that a member of one group of society who can be distinguished due to one of the characteristics mentioned in the prohibited grounds is treated less favorably in comparison with a member of a group that does not have this characteristic. If this comparison cannot be made, one might be in front of a case of arbitrariness or illegality or injustice, but not a case of discrimination. Direct discrimination is defined as an action or a norm, either legal or regulatory, which treats one person in a different way than another, solely on one or several of the prohibited grounds. There may be other reasons for the distinction too, but if they are not sufficient to pass the test on necessity and proportionality, the action or norm constitutes direct discrimination. If the different treatment stems from a norm, the Committee on Economic, Social and Cultural Rights also speaks of formal discrimination. Indirect discrimination, to the contrary, occurs when there is a general rule for everyone, but the effects that this rule has on some sectors of the population, due again to prohibited grounds, are more onerous or simply negative. For example, an employer might be asking for literacy as a requirement to apply, although not required for a job that in principle can be done as well by men as by women. In a country in which illiteracy among men is 15% and among women 45%, the requirement is likely to have the effect that women will not have equal access to the job opportunity, all other things being equal and despite being qualified without literacy skills. This effect is called indirect discrimination. Finally, there are some specific phenomena to be taken into account. If a person unites various characteristics for which discrimination is prohibited, it is often the case that he or she suffers multiple discrimination. For example, an indigenous poor woman may be discriminated against due to her ethnic origin, sex, or her economic status. Often, however, she will be treated in a discriminatory manner for a combination of these characteristics. In comparison with a non-indigenous poor woman, or in comparison with an indigenous wealthy woman, or in comparison with an indigenous poor man, she will be worse off. But especially in comparison with a non-indigenous wealthy man, she will suffer multiple discrimination. Another phenomenon is structural discrimination. This refers to situations in which discrimination occurs due to a social and cultural substratum or structure, which can only be eradicated through measures of education, training, and changes in society at large. In this sense, for example, the Inter-American Court of Human Rights ordered Mexico, in the cotton field case, also called Ciudad Juárez case, to adopt measures to eradicate sexism that had led to general tolerance of violence against young women and discriminatory treatment to their families seeking justice. Such structural discrimination is often the result of historic inequalities, such as colonization or injustice against women, and as I just said, is not easily remedied. States, nevertheless, have an obligation in international human rights law to take measures towards abolishing causes and effects of structural discrimination. This can be done through transversal public policies that foster non-discrimination in education, health, housing, access to property, etc. These public policies include legal or constitutional reforms if necessary, training, non-discriminatory language in forms and discourse, and sometimes also affirmative action. Affirmative action is the adoption of temporary measures which benefit the discriminated group more than other groups of society, in order to allow the group members to overcome historically entrenched disadvantages. Such affirmative action can consist of special scholarships or quota in Congress or cabinet to foster political participation of women or ethnic groups, or measures the like. These measures are usually heavily debated, even by disadvantaged groups themselves, but in several cases have proven efficient. Classic examples are measures that have been taken in South Africa to attempt overcoming structural discrimination expressed through a system of apartheid, that is, institutional discrimination on grounds of race. As can be deduced from the examples given, discrimination is not only, albeit often, an issue of minorities. Discrimination can well operate through structures that allow a minority distribute rights, privileges, or property among itself, at the expense of large majorities who show one or several traits that make them victims of discrimination. Finally, discrimination on the grounds of race and the crime of apartheid is prohibited through a norm which is recognized as a norm of jus cogens in international law. This means a peremptory norm that cannot be derogated by any means. In the Americas, furthermore, the Inter-American Court has determined that the prohibition of discrimination on itself, covering all recognized grounds, constitutes a norm of jus cogens. Even if this status is not recognized in other regions of the world, international law makes clear that the prohibition of discrimination is at the core of human rights law. Please visit mucchile.com and do watch the next class.